So in this paper I'm going to discuss the Northern Irish perspective, and Mairead's going to talk a little bit more about the Irish referendum and her work around that. So what I really want to talk about today is the role of human rights in abortion law, reform, debate and discussion in Northern Ireland. And as many of you know, human rights have taken on a bit of momentum in the past couple of years in our discussions around the law and its reform. However, they haven't yet facilitated any tangible legal change. So this has led to a bit of a frustration with rights in Northern Ireland and abortion law. And I want us to just reflect on this frustration and this dissatisfaction that we often feel with rights. And I'm going to offer some counters to that and some ways to reapproach or re-understand the role of rights in our abortion law debate in Northern Ireland. So just to begin with, to provide some context on human rights and their link to reproductive health more generally. So I'm aware not everyone in the room is a lawyer. So just to provide some information, international human rights law, and by this I mean the United Nations, its treaties, conventions and soft law provision, has had a long-term connection between itself and reproductive health services. And by this I mean access to reproductive education, contraception and abortion services and so on. And from really the 1960s onwards, we see a connection between human rights and reproductive health. And this emerges, first of all, in 1968 in an international human rights conference in Tehran, where it's declared for the first time that couples have a basic human right to decide freely and responsibly on the number and spacing of their children, and a right to adequate education and information in this respect. So this is the first time we really see the link between human rights and reproductive health. This is solidified in the 70s and 80s with two World Population Conferences, 1974 and 84 in Bucharest in Mexico. And there we see the language of reproductive rights really being developed. So there's a bit of a debate in the literature as to what extent these developments were driven by a feminist equality agenda as opposed to a more cynical population control agenda. But nevertheless, by the 80s we really see reproductive rights beginning to develop. This is added to in the 1990s with the Women's Rights Are Human Rights campaign. So we have a group of lobbyists, scholars, NGOs coming together in the 90s to really critique international human rights law and what they perceived as its masculine origin or its ability to only speak to issues affecting male subjects. And we have scholars like Rebecca Cook arguing that existing human rights like the right to life, the right to health, right to be free from torture, should apply to issues like violence against women, rape in times of conflict, and also reproductive health. So we start to see a real strong link being made in the 1990s in terms of furthering the reproductive rights agenda in international law. So from this development, international human rights law has been a real vehicle for change. We can look at states like Argentina, Colombia, Nepal, Brazil, where legal and policy change has really been implemented and facilitated by the international human rights regime. At the regional level in Europe, we have an additional human rights framework, which is driven by the European Convention on Human Rights and adjudicated by their court, the European Court of Human Rights. And in the European level, we see a similar pattern of increasing awareness of reproductive health issues, and in particular, critique of restrictive regimes for access to abortion. So from the 1990s onwards, the European Court of Human Rights has used the Article 8 right to private and family life, and to a lesser extent the Article 3 right to be free from torture, cruel and inhumane and degrading treatment, to talk about reproductive health issues. And we can look at case law from Poland, Malta, Ireland, for example. So at the international level and the European level, we have this discourse that human rights help us facilitate law reform and help, in particular, facilitate access to abortion services. So what about Northern Ireland? What about us here? Well, at some level, human rights have always been part of our discussion on abortion law reform. So as early as 1993, the Standing Advisory Committee on Human Rights talked about our abortion law as a human rights issue. And this was, of course, really significant because it predated the 1998 Human Rights Act. So that was quite a bold move. From 1999 onwards, we have the UN CEDAW Committee, which is the Convention for the Elimination of All Forms of Discrimination Against Women, commenting on Northern Irish abortion law in its periodic review of the UK government. So every 4 years or so, CEDAW picks up on this issue and critiques the government over it. However, beyond that, human rights haven't really taken centre stage until 2015. So from 2015 onwards, human rights come to play more of a central role in our discussion about what the law should be in this area. And this came with two significant developments. So these may be familiar to many people in the room. The first is the Northern Ireland Human Rights Commission's application, and the second is a CEDAW optional protocol investigation report. So just to provide some comment on these two developments. In 2015, the Human Rights Commission instigated judicial review proceedings challenging the prohibition of abortion in Northern Ireland in three circumstances. And those were fetal abnormality, serious fetal malformation, and pregnancy following sexual crime. And the Commission argued that prohibition of abortion in these circumstances isn't human rights compatible. So the case was heard at the first instance by the Northern Ireland High Court, who said, yes, there is in fact an incompatibility in two of those circumstances, and those were fetal abnormality and sexual crime. This was a very significant case for a number of reasons. So it was the first time that the courts here had considered the substance of our law. They hadn't been asked to adjudicate on that before. And it was also the first time that human rights were used to think about the law and to consider its compatibility with our international commitments. So the High Court also very significantly made a declaration of incompatibility that placed the onus on Stormont, on the local government, to introduce remedial reform. This case was then appealed to the Court of Appeal, who reversed that decision and said there is no incompatibility, and it's been appealed further to the UK Supreme Court. And you can see there an image of the case being heard in the Supreme Court in October last year. So that's the first development. The second is more recent, and this came in February of this year, when the UN CEDAW committee issued a report following an investigation in Northern Ireland. And while this report came about in 2018, it really has much longer a heritage. In 2010, the Family Planning Association for Northern Ireland, NIWEP and Alliance for Choice made a submission to the CEDAW optional protocol inquiry procedure. And what this procedure allows the committee to do is to investigate allegations of grave and systematic violations of the Convention rights. They came to Northern Ireland in 2016 and they undertook this investigation. They talked to lawmakers, policymakers, women, other stakeholders, and they made their report in 2018. And what the committee said was there are a number of violations with our current law in Northern Ireland in relation to abortion. They recommended a few things: decriminalisation, a new legislative framework providing access to abortion, and also a number of other actions involving enhanced reproductive health education. So from these two developments, human rights have really came to the fore. They have taken on a really ostensibly central role. But they haven't facilitated law reform. So the Human Rights Commission's application, we're still waiting on the UK Supreme Court decision. If there is an incompatibility, the collapse of Stormont, absence of local government, means we're not sure if there even will be remedial reform. The CEDAW committee's report, the UK government has responded to that and has said that they don't agree that there are violations occurring and that they have no plans at present to reform the law. So while human rights have facilitated discussion and debate, we can't say at present that they've taken us any further than, for example, the cases of Savita Hlap-Navar or Sarah Yurt. So this has led to a bit of a frustration. We feel dissatisfied with human rights. We feel that they haven't got us where we want to be. And this has led to the question of, well, is Northern Ireland just an international outlier? Is this a state where human rights don't work? They've worked in other states, but here they're just of no use to us. And this is what I want to think about. And it's my argument that this dissatisfaction that we have with rights is not fatal. So I don't think it needs to mean we have to give up on human rights in abortion law reform in Northern Ireland. And what I want to do is to offer some counters to this. Some counters to our frustration with the language and discourse of human rights that help us re-understand what they do and their connection to the process of law reform. So the first counter that I want to offer is I argue that we need to understand that it's not possible to guarantee reform via human rights. So we often think of human rights as vehicles to get us to this end point of reform. We have a legislative change we want in mind. Human rights will get us to that point in a linear way. That's often how we think. But actually, law reform doesn't happen like this. Law reform is inherently messy. It's unpredictable. It takes multiple twists and turns, and it never follows a linear trajectory. And sometimes we forget about this. So I argue that when we re-understand this or come to appreciate this, it means we need to stop evaluating rights in terms of the progress that they facilitate towards reform. We can't judge them in terms of how far they get us in this linear progress. It doesn't work that way. And following from this, secondly, what I think it's important to do is to focus on the process that human rights facilitate, which is equally as important as the outcome. So the outcome of reform, of course, would be great. We would like that to happen. But human rights are also valuable in terms of the process they facilitate. So what they serve to do is open up new ways of thinking, new languages with which we can discuss our local challenges and problems. And importantly, they also open us up to new audiences. And this has been very significant with the past recent developments that I mentioned. So if you think about the UK Supreme Court case that they're currently hearing, this has put abortion law reform on the agenda in Great Britain, in the mainland, in a way that hasn't really happened to date. We have legal professionals, but also the public, discussing Northern Irish abortion law and becoming more aware of it. And that's a very significant development. When we think about the CEDAW report, this opens us up to an international audience in a way that's unprecedented and places the spotlight on our law and the process of reform, again, in a way that hasn't happened to date. So in this way, human rights really are democratic tools. They offer us a way into a process that is very important and valuable, and we shouldn't lose sight of that. And finally, also, I think that it's important to realise and to comprehend that the achievement of legislative change, so getting reform on abortion law in Northern Ireland, is inherently open to chance and contingency. If we're going to get to a process of law reform, it's going to happen with a combination of factors, probably internal, external, when those things all stack up. So human rights as a discourse can't alter this. They can't help us predict or provide a roadmap for reform, but they are part of this process. They're part of creating or engendering those contingent circumstances that may lead us to reform. So when we appreciate these things, I think we often forget some lessons emerge, and I just want to finish with these. And the first lesson is locally, and it's a very important one. When we understand human rights in this manner, it allows us to view our frustration with rights in a new way. We can come to appreciate human rights as democratic tools, as offering us a way to navigate the complex and unpredictable process of law reform. They can't guarantee us to get to that point, but we can reevaluate their uses and what they do offer us, and this is very important. However, I also think that viewing abortion law reform and the connection to human rights in Northern Ireland in this way also offers some international lessons. So I mentioned at the beginning that we often think about international human rights law as a vehicle for reform in a similar way, that it has facilitated reform in multiple jurisdictions and it's a straightforward process or a straightforward recipe. But actually, when we reflect on Northern Ireland and our experience, this signals towards a need for a thicker understanding of the relationship between human rights and legal or policy change on reproductive health. It's not the case that we always work towards progress in a straightforward way. And actually, human rights and their connection to legal change is a lot more complex, messy, and more nuanced than we often think about. So in this respect, Northern Ireland, I think, is a situation where, first of all, we need to reevaluate what we understand by human rights and their connection to abortion law reform. But equally, Northern Ireland can offer lessons that are very significant for the international level and how we understand human rights and reproductive rights internationally.
Hello. So My name is McNeilly Enright. Thank you very much for having me. It's lovely to see so many familiar faces, not just because the Alliance for Choice crew are here, but also because some people are still here after the talk that I gave in the law school earlier, presumably to hear Kathryn, in fairness. So we're in the middle of a referendum campaign, and as a result, my papers lack the polish that you might otherwise have expected. I'm going to offer some reflections on kind of what's happening as I see it with the referendum campaign at the moment, hopefully as a way of opening things up to discussion. And actually some of the observations I'm going to make about the role of law in this referendum will resonate quite strongly, I think, with what Kathryn has been saying, using different legal sources and a different context. So sometimes, and more frequently now, scholars and lawyers from outside Ireland ask me what's going on and how we got here and how it's going to end. And I have now some kind of vague stock answers to these questions, which I'm going to kind of share with you. And the reason I'm going to share these vague stock answers is I think that it's useful to pause in the middle of a campaign like this and stop and watch the story of ourselves being retold to us. So I had a piece in Critical Legal Thinking, which is a lefty lawyer's blog, like last week, where I was kind of talking about some of the meetings that I've been doing and that other lawyers and lawyers for choice and doctors for choice and so on have been doing up and down the country. And kind of watching a lot of, I suppose, rural grassroots activists and talking to them about how their work and their engagement in this referendum campaign is not being reflected in the stories that are being told in the national media at all. And this is such a kind of a classic feminist problem. There's a classic women's history problem going on here. And I'm interested in women's legal history. I'm interested in how we tell the stories of law reforms that benefit women, who's responsible for them, who gets the credit for them, how they come about. And so I think it's important to keep doing women's legal history in the present. And I want to kind of apply some of the lenses of women's legal history to what's happening, I think, in this referendum. The first question is kind of how did we get here? I was talking in the law school earlier about this book that I wrote with Fiona de Laundress, Repealing the Eighth. And one of the kind of observations I made was that, like, Fiona and I and, the people who taught us and the people we work with have been arguing for repeal of the Eighth Amendment every day for quite a while now. And now it's happening and everything speeds up. And in that closing down of temporality, everything simplifies. And a new story kind of emerges about how the Eighth Amendment is going to be repealed or not repealed that bears very little resemblance to what we've been doing for the last 5, 6 or longer years. For me, and for lots of people my age, it was the death of Savita Halappanavar, but of course for the people who taught me, it was Miss X and it was before. There is the emergence of a liberal incrementalist story, kind of emerging under, let's call it #facts, which tells us that the repeal of the Eighth Amendment is something that has emerged almost exclusively through the parliamentary agenda with the assistance of lobbying in international human rights and other political forums. And it tells us that the journey to repeal the Eighth started in the Citizens' Assembly, which was a model of balance and deliberation, which is interesting. Like, the dropping out of memory is really important to the construction of liberal incrementalist history, because of course the Citizens' Assembly, although the result was exactly what we wanted in many respects, was very frustrating to watch. It was very frustrating to watch the frame of 50-50 balance being imposed on what was a complex lived issue. And the Joint Oireachtas Committee was able to correct some of the effects of that imposed and forced balance, particularly in terms of the legal information that was shared about, for example, the law in other countries or the possibilities of law reform. The Joint Oireachtas Committee was able to correct that because there were so many fantastic women on the Joint Oireachtas Committee. But the story is Citizens' Assembly, Joint Oireachtas Committee, referendum bill, and now draft legislation. And now we're in the process of a referendum, and we have a civil society platform, and we have party political campaigning, and the mainstream media recognise some aspects of the civil society platform as law reform campaigning, and they do not recognise others. And the story of party political campaigning is a story, by and large, of the consciences of powerful men. It's our version of the story of Liam Cosgrave, for example, crossing the floor to vote against contraception. So we have a story that is about institutions and deliberation within institutions and institutional sifting of legitimate evidence. But there is another story of how we got to the repeal of the Eighth Amendment. Some people will tell you it is a story of women's death, but it's not really. It's a story of women's retelling of other women's death. I think the story of how we got to the Eighth Amendment is a story of women's narrative. So yes, the death of Savita Halappanavar is what we remember as kind of ground zero, let's say, for this campaign. But people sometimes forget that before the death of Savita Halappanavar, Termination for Medical Reasons came out. 3 members of Termination for Medical Reasons came out and spoke to the Irish Times about their experience. And that's not that long ago. But the thing that struck with me when I was kind of writing about that at the time, blogging about that at the time, was a line, and I don't know if it was put in their mouths or if it came from their mouths, but a line that they couldn't be associated with the abortion issue, that this was different. And whereas, of course, now they're at the centre of this abortion law reform campaign. And women's narrative is what made this law reform possible. Women telling the stories of exceptional and devastating abortions, exceptional and devastating pregnancies, but also women telling the stories of ordinary abortions and ordinary pregnancies. Women telling abortion stories at multiple sites and in multiple different ways, using multiple different resources. That's one way that we got here. Women started to tell over and over, and are still telling today, the story of abortion that they hadn't been allowed to tell before. And maybe the death of one woman enabled that, and then with Miss Y, the torture of another woman enabled that. But there is a time lag, a long lag, between those two stories, and it was women's insistence on telling, retelling. The art theorist Tina Kinsella writes about the Greek legend of Demeter and Persephone, and she talks about the story of Demeter and Persephone, the mother and daughter who were separated. And she says, this is the great kind of political feat and achievement of patriarchy, is that it severs, for a lot of the time, not the whole year in the story, but it severs for a lot of the time the possibility of connection and communication between women about the most intimate and powerful aspects of their lives. Women's narrative, we're in the other season, I guess, of Demeter and Persephone, where women get to talk to each other and produce that power and see what can be done differently. But it's not just women's narrative. It's also women's transgression, women's law-breaking, women's refusal to be bound by this law. You see these posters in Dublin now that say, don't bring abortion here, but of course the story that we've always been telling is that abortion is already here. Women, that law exists only as a morality clause. Like all morality clauses, it is more honoured in the breach than in the observance. Women have been breaking that law. Remember, the abortion rate went up by a few hundred after 1983. Women have been refusing to be bound by that law for 35 years, and that refusal has been made more and more visible. Women have been engaging in a form of peer-to-peer education in the course of that narrative and in the course of that transgression. Remember, some women were told the story of women getting abortion pills on their own, kind of out of the internet, as if out of the sky. But of course, women get their abortion pills from women on web. Women get their abortion pills from their friends. Women get their abortion pills from local activists. Women find out how to take their abortion pills from organisations like Need Abortion Ireland. This is what I've written about this, those who used to distribute condoms did in the 1970s. It wasn't just the condom, it was the story about how to use it and how it was okay to use it and how you'd get by and it wouldn't be the end of the world if you did. So it's the peer-to-peer, it's like that, the coming together of the public political subjectivation, women asserting, making themselves visible, asserting themselves as whole citizens, but knitting that together with ongoing peer-to-peer, person-to-person engagement storytelling. Of course, it makes a difference that there have been women in Parliament to amplify those stories. It was, recently for research I was reading the 2002 Oireachtas Committee hearings that led to the Green Paper on abortion. I think there was one woman in that hearing, I think it was Liz McManus. Whereas the Joint Oireachtas Committee, there were so many women sitting together in a row, pulling together, making decisions about who would be called as expert witnesses and so on, making the decision, especially people like Lynn Ruan, making the decision to amplify the voices, particularly of marginalised women, as well as women who can appear most like the mainstream. When we think of, Monica Barnes died this week, and one of the excerpts from her contribution to the debates, I think after 1983, was this back and forth between her and the Ceann Comhairle where she's asking for 1 minute on behalf of Irish women. But in the Joint Oireachtas Committee, we got days and days and days. And that is transformative. If we tell a story, even if we get a yes vote, and if the story law teachers tell law students is that our system of law reform worked, that our system of constitutional change worked, if that's what we teach, that won't be the full story. The story is women pushed and pushed and pushed, did not compromise, did not shut up, amplified each other, supported each other, made the law livable in the interim, made clear that they could make the law livable even if they failed to change it. This is women. And that maybe this isn't much of an academic talk, but this is what I'll tell my students, is that it was women who did this and not necessarily the system. The second thing I hear from foreign academics is like, how come Ireland has gay marriage and not abortion? And this is, of course, a very original and provocative question. And then you get, well, isn't this completely different to marriage equality? And I remember very vividly on the day that we won the marriage equality referendum, I was giving a paper about abortion at the Constance Markovich Summer School to what started as 100 people, and by the end of the talk was like 3 people, not because I was so terrible, but because the text messages were coming in to say people were gathering at Dublin Castle, and if you wanted to be there, you had to go now. So there was lots of like, I'm so sorry, God. and of course, I didn't get to go to Dublin Castle. I had to make do with the front lounge, where I think there was 1 keg of lager left or something by the time I arrived. But Anthea McTiernan spoke at that Constance Markovich Summer School. And she said, this referendum is about love, and she said the next referendum has to be about love too. And I thought, for God's sake, like, no, this is about abortion. Abortion is terrible. Abortion is not about love. But actually, I think this is like marriage equality. It's like marriage equality because it's about sexuality. If there's one thing this referendum is teaching me, and I think I always knew it because I grew up in Ireland, is that it is worse to be a woman than it is to be gay. I mean, I think that lesson is being really clearly taught. This is about women's sexuality. This is about the possibility that you might have sex and not become a mother, or the possibility that you might have sex and not take the obligation of becoming a mother potentially, over and over and over again. It is about sexuality. This referendum, like the marriage equality referendum, is about parenting. I mean, look at all of these posters and social media campaigns with all of these lovely mammies holding lovely babies, right? It's about motherhood, it's about family, it's about adoption, it's about the possibility that if you don't have an abortion, you should be giving up your children to respectable two-parent families. It's about stigma. The opponents are the same. It engages the same obligation of those who are asking for their rights to disclose over and over and over again what law's refusal has meant to them. And it is also, it's an empty signifier. Like repeal, like marriage equality, is an empty signifier. This referendum stands for as many things as it possibly can stand for. For some of us, it stands for reproductive justice against the alternative, which isn't very clearly articulated. But it also strikes me, particularly in rural areas, that it is an empty signifier because it can stand in for the closest thing I think that Irish women have gotten so far to a form of transitional or intergenerational justice. So it is significant, I think. It always strikes me as significant that we are having this referendum at a time when we are more aware than we ever were of the injustice of historical gender-based violence, not just in institutions. Even the Minister for Health, which is always a bittersweet moment when you see the boys taking your feminist discourse, but even the Minister for Health, when he introduced, I think, what was it, the referendum? No, it was the response to the Joint Oireachtas Committee. In the Dáil, he talked about, Kerry Babies was in the news again at the time. He left out some physiotomy because that's a terribly inconvenient one for this government, but he mentioned the Magdalene laundries, chewing babies and so on. I don't mean to suggest that we did our best by those women. I don't mean to suggest that justice was done for them, but I think that they did the generations who came after them a tremendous service because they allowed us to make that connection. They allowed us to see that even though abortion is privatised and if abortion is individualised and you are no longer put into an institution, that the links of stigma are the same. And I think that in the conversations that people are having, in the course of canvassing, in the course of families, when people come up to stalls and tell their own stories, when people tell their own stories perhaps for the first time on the doorstep, I think that is the closest thing to a moment of public transitional justice that we are going to get. And again, that's not necessarily coming from institutional places. that's coming from the relational aspect, right? So as Kathryn says, right, is this a referendum about constitutional rights? It is, yeah, sure. But it's the process, and it's the signification, and it's the contestation, and it's the discussion that makes the politics, that gives the idea of rights any kind of relevant purchase. So what are the challenges that this campaign is facing? I mean, I'm not going to, again, to my imaginary foreign academic, I mean, there's a lot. It's really surprising to me what kind of a role nationalism is playing in this campaign. The famous poster, 1 in 5 babies in England. And people try to contest that on the basis of the statistics, and I think that misses the point. The most important word on that poster is England. Right? Not like England. We can't be like England. We mustn't be like England. Save the Eighth have produced, I really want one if anybody can get me one, beer mats that on one side show a kind of a fetus who is, of course, visible through the flanks of the woman carrying it, and on the other side has the proclamation of the Irish Republic. And if that is the most fantastic artefact of fetus-centric nationalism that I've ever seen. But there are others. There's one of the slogans of the Save the Eighth campaign, for example, is Join the Rebellion, which has both the connotations of a kind of Trumpist anti-government sentiment, but also is invoking this idea of national sovereignty. Secondly, of course, the Eighth Amendment. I mean, I don't know how to classify this one, but I saw this on the Protect the Eighth website yesterday. And if you go on to Protect the Eighth, you will find a page that says, who am I? And if you click, you get the answer, I am the Eighth Amendment to the Constitution. I was conceived at a time when Western parliaments, without recourse to the people, introduced laws permitting the direct and intentional killing of unborn babies. And it goes on and on. I recognise the right to life of unborn babies. I defend and vindicate. It's personified, right? It is the personification of the values of a deeper national consciousness or something, which is very strange. But for me, that kind of artefact shows the very deep association between law and national values. Of course, as well, despite the kind of secularisation of Eighth Amendment discourse, there are still the residues of a religious perception or framing of pregnancy, which is communitarian, not individualist, which is highly fetus-centric, which, of course, moves away from the institutional history of demonisation of single womanhood while still disciplining motherhood by suggesting that abortion cannot be part of the proper functioning of reproduction, cannot be an aspect of maternal life, even though we know from women's histories that it's quite a normal part of mothering, of parenting over the course of a woman's full reproductive life. Another thing that's interesting to me is that the legal complexity of this referendum, or the perceived legal complexity of this referendum, is a significant challenge to our side in the campaign, and has proved to be something of a boon to the other side. And I'll discuss that in a little bit. What are the internal challenges? If those are the external challenges, we know this already. One is inclusivity. Like, how do we stop? Particularly when the other side's discourse is so negative, so punitive, so regressive. How do we maintain an open and inclusive account of reproductive justice, that does not fall back into dichotomies of good and bad abortions, that takes account of the needs of women who are marginalised? That can remind us that Northern Irish women are participating in this campaign, which was something that we were talking about at the law school earlier. Was really interesting to me how difficult it is to maintain a discourse of abortion as normal when it is easier to fight on the basis of life and death, right? So, for example, you can see this in the discourse around the abortion pill. So we've been saying for a long time it's safe and it's a way for, and women are taking this into their own hands, and it is used in communal and familial contexts. And what's wrong with it is that if a woman is worried or if she's concerned, she doesn't feel that she can go and get medical help, and criminalisation has its own stigmatising and chilling effects, right? That's what we've been saying. But if you look in the government's discourse of why the abortion pill is wrong, it's getting quite close to the line of this is dangerous. And the role of government is to intervene to protect and regulate because women are in danger. And how, that's very difficult. It's very difficult to maintain abortion discourse in that kind of, in the ground where we've been trying to keep it, of this is normal, this is healthcare, and so on. Also, the speed of campaigns is hard. This is a complex and fragmented issue. It's a complex legal issue. And it is hard to maintain, particularly for academics and for people who are involved as policymakers in the campaign, to maintain that slowness that is necessary to deliberating over best practice. And that, by the way, is why it is so important that we get politicians to accept that whatever the referendum, whatever the legislation, this can't be, as you were saying, the final word on abortion. Like, progress is not linear and leading to definite and final outcomes. It is important that we recognise that it will be necessary to reflect on this law, maybe to review it in 3 or 4 years, to check that it is actually working, and so on. So the final thing I kind of wanted to ask was, what's the role of law and lawyers in this campaign? And this is what I was talking about in the law school, so I kind of won't repeat too much of what I've been saying. I mean, so Fiona and I wrote a book. We have a website called About the Eighth, which is essentially a kind of fact-checking website. A couple of years ago, I set up Lawyers for Choice, which, to be honest, for a while was just 3 of us in a Twitter account, but now is 120 members, including actual practitioners and so on, right? Which is launching a leaflet in Dublin and as we speak. So, you know, I have tried to intervene in this debate as a lawyer. I was saying in the law school that I kind of am reluctant to take up the title of scholar activist, particularly in this city, because there are so many people who do that job so much better and who do it without many of the luxuries and institutional supports that I enjoy at the moment. But I think there is something important that we're learning from lawyers' participation or non-participation in this referendum. I think, first of all, it's very clear that there is a need for public legal education and that is an important part of any campaign. I'm not saying lawyers have to be the ones to do it, but I think that the misinformation around the law that is central to the Save the Eighth campaign in particular is really challenging and really worrying and profoundly unethical for any lawyers who are involved with them. So, you know, they are in particular manipulating aspects of the proposals around disability, around mental health, around time limits and viability. And I think, to be quite fair, they have learned particular tactics from American pro-life, I suppose what's called lawfare, which is that if you have very well-resourced lawyers, you can make bad arguments. You can make them over and over and over again. And it doesn't matter if they don't work, because you can always afford it. Whereas if you are a lawyer for yes, and you have a sense of ethics and integrity, you can't just fling bad arguments back, right? And maybe there's something there about how campaigning is done under the alt-right and so on. But when I talk about public legal education, I mean legal engagement that empowers activists and empowers voters, that gets away from this kind of language of technocracy and mystification and starts talking about how the law actually impacts women's lives. I think that's why there's been a real role for feminist lawyering in this campaign. I think that's why so many Irish feminist lawyers have been attracted to contributing to this campaign, whether they are based here or in the south or whether they are based in England. I think it's what's important and what's different about the way that groups like Lawyers for Choice have been trying to engage is that, unlike in 1983, we recognise that lawyers are not the only people who can talk about law, and that when we are having national discussions about law and there are multiple voices, the lawyer's voice doesn't necessarily belong at the top. The public sphere is not a court. We're not, our role is to make sure that people are informed and engaged in the process of legal change, but artists, activists, ordinary women, whoever, they have stories to tell about law too, and our job is to explain them and lend them weight and coherence. Our job is not to impose an alternative technocratic discourse on that. What I will say as a kind of a positive note is that certainly what Fiona and I have found is that this is, we spent so long under the Eighth Amendment critiquing it or trying to find tiny spaces where it might be livable and workable. We've spent our whole time going to international human rights tribunals and so on and saying, look, this is terrible, tell the government it's terrible, explain why it's terrible. Now we have a moment to put to the people a case as to how things could be otherwise. I am relieved that the government's legislation is actually, I'm reasonably happy to defend it up and down the country. It's actually, it is not the PLDPA light. And clearly some of the lessons, particularly around mental health and delay and so on, have been learned properly from the PLDPA. But there is an opportunity at this moment particularly around discourses like the common good, particularly around ideas of fetal rights and maternal rights and so on. We can talk about that in more detail later. This is an opportunity to inspire people. The point of a referendum is that we reevaluate the core ideals that are underpinning our fundamental law. This is an opportunity to say to people how things could be different, how we could have a law that protects and supports and empowers women rather than constantly, negatively, prohibitively beating them back, forcing them into a role to which all women cannot subject themselves. We have an opportunity to overcome the worst of formal rights discourse and start to think about the Constitution as part of an ongoing, more progressive politics. But at the end of that, I think we also have an opportunity to articulate a law which knows its place. It may be that what we need after repeal of the Eighth Amendment, it may be, and I say this because I know that Caroline Simons apparently picked me up on this at a talk in Waterford last week, it may be that what we need to move towards ultimately, though this is not what the government has proposed and this is not what we're looking at now, it may be that we need to move towards a law that knows its place, towards a law that retreats out of women's reproductive lives insofar as possible and is present where necessary to support women to access the services that they need. So this is a really hard time, but this is a really exciting time. And there's so much possibility, and I'm so grateful to everyone from Alliance for Choice for slogging it out with very little recognition oftentimes. And I will be on Facebook with you or in person on the 26th when we have won the bejesus out of this thing. Okay.